Oh, let's see. Yeah, sitting in the car, 5:30 a.m. Lady of Lords. Me and my baby sister Mandy, 19 years younger than me. There's four of us. I have a brother and two sisters. And look, plane passing right over me. Well, she just left the Lafayette Airport. Right over a lot, flies low. Anyway, I got the sunroof. Anyway, yesterday, while searching for medical documents in my mom's room, mistakenly found a fresh, clean copy of a legal document going back to 2017. You know, I tend to know exactly, well, I tend to have a really good idea. Exactly, yeah, exactly what the fuck is going on around here. And I'm going to read a document because the public needs to know. And I don't believe in mistakes. I believe I mistakenly or accidentally found this document, but I don't believe in accident. I think I found it at the right time because this is a document that was drafted and written by a friend of mine, Matthew Lulla. Matthew Lulla, the son of another friend of mine, Chris Lulla, owner of Preventive Maintenance Services. He was a long time, very good customer of mine. Always treated me with respect and called me when he needed something. We put our heads together. We figured out solutions. We designed and built parts and, all this kind of stuff with these big, slow speed engines, Waukesha's, and all of them anyway. He built big engines that he sent all over to gas production plants and whatever. But anyway, Chris is a very intelligent man, and I had respect for him. I still do. And I met Matthew through him. Our first fishing trip to the Gulf with Chris. I was invited on the Gulf Diver. We went out on Saturday of an Easter weekend of 2,075 miles out, stopped in 125 feet of water. I forgot the location, but it was glass calm, crystal clear water. You could see damn it to the bottom. I mean, beautiful water, beautiful conditions. Very rare you get that glass calm that far out. Matthew and I put on our scuba gear, went scuba diving, spearfishing, came up, pulled in red snapper till our arms hurt. Me, Matthew, 3 or 4 other guys, Chris. We had a wonderful time that day, and I remember we filled up a 4x8 plywood box that might have had a third high in ice at the bottom, but we had that thing full of red snapper and snappers all the way around it. I mean, there was 6 of us. When I got home, I had at least 40 snapper, my share. It was an excellent trip. That's how I met him. Anyway, that's the backstory. But anyway, Matthew, as he got a little older, a little later, he went to college, got a law degree at Loyola, working for his dad, befriended him again. So he was a friend of mine. So, very, very intelligent guy, too. Look, and I'm going to read this document. And you'll see how intelligent he is, okay? Law degree. And also his style of writing, which is top-notch. His writing skills are just beautiful. And he has his own flair of, what I would call satire and sarcasm to it. But what I'm going to read you is a 9-page document that he drafted. He called it a briefing document from Matthew Lulla to Civil Rights Division of FBI, U.S. Attorney's Office, and or whom it may concern, suspicious corrupt activities within the 16th Judicial District, adverse to the civil rights of Kent McGahee. Introduction. As a reader, we'll see there's a great deal of evidence, much circumstantial, but some direct as it, and even documentary that indicate collusion between acting law enforcement agents working outside of the course of scope of official duties, and at least one private attorney with strong and known ties to law enforcement in the 16th JDC. Both the scope and speed of law enforcement reaction throughout this twisted affair strongly indicate the presence of undue influence. The purpose of this collusion was to gain an unfair advantage in an ongoing civil litigation by framing Kent McGahee for crimes relevant to that litigation. The pertinent events here begin with the civil litigation between two former spouses, Kent McGahee and Lisa Tucker, regarding the former community property that they still co-owned in division according to their divorce agreement. Okay? Ken initially employed an attorney who filed a civil suit for damages due to Lisa's alleged mismanagement. See Exhibit A. Lisa employed another local attorney, Mr. Jacques Cousin. Please note that Mr. Cousin is a former assistant district attorney in the 16th JDC, and this will be relevant going forward. Preliminary notes. I, Matthew Lullah, author of this document, have known Kent McGahee for over 20 years. Further, I helped him administer his former business, Macro Machine Shop. During that time, I also administered the operation of a storage unit rental business located on the site. He was technically the oh shit, let me turn my light back on. Where was that? Okay, all right. This was technically the responsibility of Lisa Tucker, Kent McGahee's ex-wife, pursuant to the divorce agreement. However, since she was never there, we were there every day. Either I or Kent actually leased the storage units, collected the rents, and forwarded the payments to Lisa, amongst other normal operations. Because I was present for many of these events described herein, I will also be a witness to my direct observation in any legal proceedings. While I have not engaged in the practice of law for about a decade, I nevertheless am a lawyer, and as such have all the required knowledge and training to recognize the importance and relevance of the types of evidence that are discussed herein. Therefore, evidence will be attached here too. Where evidence is testimonial, the persons will be identified with contact information. Where the evidence is documentary, the pertinent documents will be attached. Oh, it gets really good. You're going to see what these people are about. All right? It's insane. But it's all true. All true. Okay, where evidence is known or suspected to exist, this will be indicated along with the probable location of such evidence. Activities of Chris Feller. Yes, Chris Feller. You thought I forgot about you, Chris? Nah, I didn't forget about you. You didn't get away with a fucking thing. You didn't get away with anything. Fucking snake. Okay, on or around 2015, an individual named Chris Feller, proprietor of a local business, Louisiana Small Engine Repair, leased shop space in the front of the property. Shortly thereafter, Kent brought to my attention rumors that Mr. Feller was, in fact, an undercover police officer. I advised Mr. McGahee of a few pertinent things. First and foremost, this was a rumor, and is the nature of the beast likely to be untrue. Secondly, even if this were the case, an undercover police officer would almost surely never be undercover in the community that he lived and had substantial history, making it also unlikely that he would be acting in any official capacity. Finally, just in case these rumors were true, I advised Mr. McGahee to remain silent by pointing out to him that it would be morally unacceptable to compromise his safety by spreading such rumors, even if he were spying and the rumors were true. Later, we would discover some pertinent facts to cast our suspicions in more credible and ominous light. Chris Feller is a police officer with legal problems arising from his work conduct. He has been fired from IPSO. Okay, none other than Jacques Cousin, former assistant district attorney for Lisa Tucker, also represented Chris Feller regarding legal matters resulting from allegations of work-related improprieties, and statements made by Feller also indicate he was substantially in debt to Jacques Cousin. These facts alone lay out a circumstantial case for a conclusion I intend to bolster below with additional evidence that Mr. Feller acted in the direction of his attorney to violate Mr. McGahee's rights by surveilling him in an attempt to detect some criminal activity, and to having failed to detect any such activity conspire with others to frame Mr. McGahee for theft and embezzlement. In a suspicious series of events detailed Later herein, Mr. McGahee was banned from the property where Mr. Feller was a tenant pursuant to the criminal bond and civil proceedings. At this point, Keith McGahee, who is Kent's identical twin brother, having developed a aforementioned suspicion about Feller, decided to conduct a mole hunt of his own by feeding Mr. Feller a barium meal of sorts. Keith, using Kent's truck, showed up at the property and pulled into the rearmost portion of the shop where Kent had previously resided, doing so quickly and closing the door afterwards in a suspiciously rapid fashion as though to avoid detection. While making sure that the event was observed immediately afterwards, a police officer arrived on scene. Keith informs me that he recognized this officer as the same man who had previously arrested him on the property, for speaking up for me. An event described more fully herein. While I do not know the name of the officer, I should be readily ascertainable via event report of IPSO. This officer had a brief conversation with Keith in which the officer stated that he was looking for Kent, and Keith stated that Kent was not present. Lisa also, via criminal complaint, initiated an IPSO investigation into Kent for the crime of embezzlement. This is almost laughable, as direct documentary evidence that the determinative of Lisa Tucker's fraudulent intent in conducting actual embezzlement is attached to this document and was presented in court. This investigation was headed by one Detective Landry. Detective Landry ended his investigation by recommending against prosecution for said crime. I have spoken to Detective Landry via telephone, and he seems like a forthright man to me, specifically one who might honestly answer questions from the reader. FBI totally ignored me. They were protecting them. You understand how deep it goes? I'm really operating in a dearth of information about the aforementioned Chris Feller. I know he's widely believed to be a dirty cop, to have violated persons' rights via excessive force and possibly to have stolen money or fungible contraband. I'm suggesting here that if someone has more suspicions than evidence about Mr. Feller's criminality, such persons should look at his small engine repair business. I'm a mechanic, and I spoke to Mr. Feller about the moped engine I was working on at the time. He was far from an expert. His business did not seem to have much volume, and I know firsthand that the retail level mechanical repair is a difficult business to make it. Most people are reticent to spend much money repairing necessary car, much less a superfluous dirt bike or four-wheeler. Most mechanics cheat their clients because they'd go out of business otherwise. I know, having gone out of exactly the business in that industry for that reason. If I had some dirty money to wash, this business would be an obvious front. Perhaps someone should look at the banking history with an eye for cash deposits linked to fabricated invoices, otherwise obtain the business's accounting information. False accusations of theft, embezzlement. Here begins what will become a constant theme herein, namely multiple examples of warrantless, sometimes forced entry into a residence and obvious manipulation of law enforcement and judicial process. On or about the evening of March 25th, 2017, Storage Unit 3 was opened by Kent McGahee. I was present at this event, as was Chris Feller. The actions of Mr. Feller at this time would later come to be seen by Kent and myself as highly suspicious, but at the time seemed to be innocuously aggravating at most. When opened, the storage unit turned out to contain a host of remote-controlled airplanes, medical equipment, and assorted other goods. Mr. Feller's made repeated attempts to purchase the remote-controlled aircraft, claiming that this was his favorite hobby. Each time, the answer was the same: no. Both Kent and I told him no less than 3 times that the unit was being empty for non-payment and that attempts needed to be made to find the owner and return the goods in recompense for the tenant's payment of overdue rents. At this time, Mr. Feller requested that Mr. McGahee send him pictures of the apparently medical equipment contained in the storage unit, claiming that he knew someone who would know that it was what it was and what it would be worth. These pictures would later emerge as evidence in an IPSO report on the incidents. I will stop to explain here that the opening storage unit that became delinquent was in no way an unusual event. This has been standard procedure for years. I personally know that Lisa Tucker was aware and condoned the practice, as I have been standing next to Ken on several occasions when he called Lisa to discuss tenants' delinquency before opening the storage unit. Previous to these events, Lisa Tucker had provided to Ken McGahee a client contact information, along with other accounting information documenting that unit in question was seriously in arrears. I can personally attest to the fact that she knew Kent would open the unit, and when she so informed him. Another relevant fact is that Mr. McGahee was residing in the rearmost portion of the shop, which had previously been renovated by the tenant. Both Lisa Tucker and her attorney were clearly aware of this, that they had previously submitted a hand-drawn map of the property with the words, Kent lives here, my domicile, my domicile, written on the pertinent section. Shortly afterwards, the tenant of Unit 3 appeared, having somehow chosen that instant to catch up on her rent and visit the storage unit she had not opened in years. She apparently then placed a call to the police to alert them to a burglary of her storage unit. However, Lisa Tucker, who lives in an entirely different jurisdiction, managed to arrive on scene immediately. All right. All right, let's see. However, Lisa Tucker, who lives in an entirely different jurisdiction, managed to arrive on scene immediately, accompanied by none other than her own attorney, Jacques Cousin. Clearly, Mrs. Tucker and her attorney were operating with high bravado, not only failing to conceal obvious collusion, but also flaunting the same. The brazen nature of their conducts leave me optimistic that we might have left other, even more damning evidence of the same. At this point, police officers arrived and began attempting to force entry to Kent's residence, and he took tactical decisions to flee. He also alerted his brother, who promptly arrived on scene, informed the police that this was a matter of ongoing civil litigation, demanded they secure a warrant to enter a residence, and indicated that Mr. Cousin, a private attorney, should not be present at all. He was placed under arrest for seeming combative, but later released without charge. While there, he observed Mr. Cousin directing police activities. A private attorney now, directing police activities almost unbelievably, even observed Mr. Cousin leaving the scene only to return with a new grinder he had purchased for the police to cut open the door with. Presently, I paused to reflect on the significance in this order. First of all, whatever circumstances may mitigate police conduct in making a warrantless entry in here on this, the first entry, it would be obvious from the furnishings and other circumstances inside that they had entered someone's residence. Secondly, no attorney, much less the one that worked as a prosecutor, can claim to be unaware of the exclusionary rule, nor can any police officer. Further, Mr. Cousin cannot claim he was unaware that the property was a person's residence, as he had previously submitted his own client's map, boldly complaining just that fact, and even authored the correspondence complaining of the same. It therefore follows that Mr. Cousin not only knew that his civilian direction of an ongoing criminal investigation was profoundly inappropriate, but also knew at a minimum he was failing to maintain the appearance of propriety. Actually, by advising the police that they need to seek a warrant to force entry into a known residence, he was actually fatally compromising any prosecution vis-a-vis the exclusionary rule, and did so with clear intent given the knowledge necessary to his station. To put it plainly, harassment and intimidation to the benefit of his client and under the color of law was his specific intent, and he therefore did not care about the evidentiary integrity of a criminal prosecution. Finally, please note that I have been unable to obtain a copy of the police report on this incident, but I would expect it to contain the same parallel construction, meaning a false account of the events leading to the complaint and response. The fake story will involve Marlene Robideau, the tenant of Unit 3, discovering the theft, reporting it to the police. The real story is that Lisa Tucker and Jacques Cousin set up the entire affair. If I was an investigator, I would question Marlene Robideau, the tenant of Unit 3, as she is clearly the weakest link in that conspiratorial agreement. And I might also look at the order of timing of the phone calls between these parties. Okay, next paragraph. Harassment following of Keith McGahee. Subsequent to Mr. McGahee's evasion of the police on the site to his property, the police applied for and obtained an arrest warrant for his person. What followed was a true manhunt, the intensity and duration of which is simply egregious excess of a man wanted for theft. Okay, say of the Mona Lisa. Mr. Keith McGahee informed me that he was being followed constantly by the police who were presumably looking for Kent. After about a week, Keith informed me that the vehicles following him had changed, but he was definitely being followed. I suspected that maybe Keith just needed to take some lithium or something, and insisted that he pick me up, that we then take a particularly evasive route so that I might make my own judgment. Sure enough, he was definitely being followed by at least 2 unmarked cars. At a later time, our detection of this unwanted tail became so transparent and the relationship amongst the adverse parties so sporting that the cars passing in front of my house while occupants thereof, who were surely unknown to me, would wave. I would wave back a bit with a single finger. Keith informs me that he observed a placard reading Lang on the deployed sun visor of a car following him one day. Such vehicle visor bearing a family name are commonly used here at daycares and elementary schools to assist in the logistics of people retrieving their children. I know that there's an officer, Brett Lang, with IPSO. Further, I am told he's a warrant officer working closely with the district attorneys of Iberia Parish, himself a former colleague and close friend with Mr. Jacques Cousin. Throughout this time, many irregularities were observed, including cars following Barbara, Kent's mother, in a belligerent fashion, and objects being placed on the locking mechanisms of the car so as to perhaps gain covert entry, as well as a host of other suspicious coincidences. What I believe happened here, though not wholly uninformed, this speculation is as follows. Mr. Cousin probably pressured the police into a far more exhaustive search than usual, and when this failed, he switched to employing local individuals who would work for more reasonable wages. I suspect that these people were off-duty police officers, and on the other hand, these individuals could have been on duty while running Mr. Cousin's errand. Some or all of these people went beyond acceptable investigative tactics and took measures to legally surveil, search, and intimidate. All of this became irrelevant when Kent voluntarily turned himself in. But until such time, Keith was being followed by unmarked cars. Please note here that there are certain that the IPSO Central Dispatch made several call-outs on duty officers while attempting to apprehend Kent, and this may have created a documentary trail about what actions were taken and at whose instruction and instigation. Next paragraph, arraignment of Kent McGahee. These events evidence a serious and transparent manipulation of the judicial process. On or about May 30th, 2017, Mr. McGahee turned himself into IPSO. He was presented at his preliminary hearing via video conference before Judge Pittman, and his bail was set at $3,000 in the ordinary course of business. Despite there being no obvious way for Mrs. Tucker or her attorney to know of this, Mrs. Tucker managed to arrive in the judge's chambers during the preliminary hearing, and misrepresented herself as the victim of the crime at hand, theft of the contents of the storage unit. As a result, Mr. McGahee was summoned again before the judge, who starkly informed Mr. McGahee that he could either accept the additional bail condition of banishment from his residence and his property that he sweat blood for. Himself, and only himself, did it, okay? Somebody else was just there for the ride to write the checks and keep on. Let's be real about it. Okay? Where I'm at. Okay? All right? His bond was increased. If I did not accept the condition of bond, it would be increased to $100,000. As of this writing, Mr. McGahee's arraignment on the charge of theft has been continued 8 times. Clearly, Mr. Kuzan used undue influence to obtain inside information incredibly promptly. One or more persons inside of the judicial system and subsequently condoned Mrs. Tucker's misrepresentation of herself as the victim of the alleged crime. There is no conceivable alternative explanation. Further, it is worth noting 2 things. First, we only know of this because the judge momentarily forgot to mute his microphone, allowing Kent to overhear the part of the conversation. Secondly, his preliminary examination was almost certainly recorded, enabling an investigation to obtain objective and accurate evidence of these events. Subsequent to these occurrences, Mr. McGahee was represented by a public defender who, upon meeting with him, filed a motion to modify conditions of bail. Prior to the hearing of this motion, the hearing was rescheduled. I know it's long, but the people that are scared to death of me reading this or having it read to them. Okay? Most don't care. That's all right. The motherfuckers that care are guilty. That's the ones I'm reading it for. Dedicated to you, you dirty motherfuckers out there. Yeah, dirty crooks. Criminal motherfuckers. All right? Yeah, where am I? Okay, prior to the hearing of this motion, the hearing was rescheduled to a day. Oh, wait. Subsequent to these occurrences, Mr. McGahee was represented by a public defender who, upon meeting with him, filed a motion to modify condition of bail. Prior to the hearing of this motion, the hearing was rescheduled to a day in advance of the initial dates. See Exhibit C. This would be highly anomalous in any jurisdiction for any hearing, and even more so in a clearly backlogged system where arraignments are being continued for a year or over. Upon learning of this advancing reschedule on this initial trial date, and he appeared in court for Mr. McGahee, inquired at the district attorney's office and was told that a notice of this was sent to him via mail. However, not only Kent, but also his brother and mother, all of whom reside at the same address, have stated to me that no such notice has arrived. Perhaps there is some innocuous reason this particular hearing was so oddly rescheduled to a prior date. Then again, perhaps not. Okay? These motherfuckers all working together. All working together. Organized crime in the judicial by oath takers who are robbing, looting, falsely accusing, prosecuting, convicting, and even killing people, robbing of their property, everything under the guise of justice. That's what these people were doing. That's what I discovered. And it's real. Civil litigation. Here continued obvious manipulation of the judicial process, most notably Mr. Kuzan's client Lisa having and using the court's judgment prior to the court's ruling, and the judge's total failure to note or account for Lisa's then apparent perjury when Mr. McGahee's hearing in the civil matter transpired. Recall he had sued Miss Tucker for mismanagement. He represented himself, appearing before Judge Bourne in the 16th JDC, having fired his own attorney, and he lost. Hardly surprising, much less suspicious. However, there were some notable irregularities. First, and despite it being Lisa who had criminally accused Kent of embezzlement, Kent presented direct evidence in this hearing that Lisa had done just this by lying in the inducement to tenants, causing them to make checks out to her personally and then depositing those checks into her personal account, Exhibit D. Furthermore, Kent also managed to elicit clearly perjurious testimony from Lisa under cross-examination. All of this was completely ignored by the court's judgment. This also is unsurprising, given that the court's judgment was authored entirely by Mr. Jacques Cousin. We reached this conclusion. The ruling of the civil hearing, and the decision made by the judge, that judgment was authored by Jacques Cousin. How do we know that? On the basis of obvious linguistics, similarities of the judgment to the briefs filed by Mr. Cousin in a text message sent to Kent by Lisa, featuring a picture of that judgment before it's released by the court. Before it's released by the court. The picture document was identical to the court's judgment, including the numerous grammatical and linguistic errors. The court's judgment, while silent about Lisa Tucker's perjury and demonstrated embezzlement, contains a large amount of superfluous dictum and finding of fact that are determinative to the ultimate issue, but clearly well outside the scope of the rule to show cause that was before the court. On Monday, July 24th, Kent was in violation of the criminal court's order on the property when Lisa Tucker arrived in an apparent effort to show the property to a group of prospective buyers. As a brief aside, there is no reason to believe this was actually a group There is reason to believe this was actually a group of lawyers assembled by Mr. Cousin for the purpose of purchasing the property. Upon detecting Kent, Miss Tucker called the police, who arrived forthwith. Kent again chose to retreat, but not before overhearing Miss Tucker showing a picture of the judgment on her telephone to the responding officer. This fact is significant. The judge did not sign the ruling until the 25th. The day after, and it was not even filed at the clerk of court until the 28th, Exhibit E. Please note that the officer might have noted this in his incident report, possibly providing clear evidence of the conclusion before the fact. Next paragraph. Conduct of Caffrey Realty. Obviously, a realtor normally does not act under the color of law, but the fact indicates that this realtor, Mr. Pat, I'm going to add his first name, Pat Caffrey, may know much more about the activities of Mr. Cousin than I or Mr. McGahee do. As a result of this civil litigation, Mr. McGahee was forced to sign a listing agreement. Mr. Caffrey, where am I at? Mr. Caffrey, a local realtor, was retained by Cousin to facilitate the sale of the property. However, Mr. Caffrey did almost nothing to advertise the property. It was listed in a cursory fashion on the Caffrey Realtor's website for only 2 days, and then only under miscellaneous, as opposed to commercial property. No sign was placed or other indication made that at the property that it was for sale. Danny O'Quinn, Danny did this for me, who owns property adjacent to that in question, called Caffrey Realty, and when told Mr. Caffrey was not in, left a message stating that he wished to make an offer of $200,000 on the property and requested that Mr. Caffrey could contact him at his place of business. Mr. Caffrey never contacted Mr. O'Quinn, choosing instead to accept an offer of some $15,000 less than O'Quinn's afterward. If, as I suspect, the prospective buyers were a group of attorneys assembled by Cousin, this raises the question of why any realtor was even necessary. There is no clear answer. Mr. Caffrey testified in court that the property was worth less than $200,000. Even to a layman, which I admitted am in such matters, this seems disingenuous, given that the property was purchased for $200,000. Okay, and though, well, all right, more property was purchased for more than that. It was purchased for 200. He had that wrong. Though at the time there were less buildings on it, some 25 years prior. Also, the property had appraised for $485,000 in 2001. Mr. Cousin might cite the imminent foreclosure by reasons bank as the prime reason for this. However, this situation was intentionally caused by Mrs. Tucker, likely at Cousin's own instruction, immediately subsequent to Kent filing of a lawsuit against her. Mrs. Tucker ceased paying the note, while keeping to herself the rental proceeds she could have used to service the note. Mr. McGahee was not informed of this non-payment. I believe that Miss Tucker, having taken over $75,000 from the rentals business, as indicated by her incompetent answers in the context of this litigation, likely was much larger amount, conspired at the instruction of her attorney to sell the property at a depressed value in order to abscond with the stolen monies and leave Kent McGahee without the means to further litigate the matter. If this was the plan, Mr. Caffrey would know as much and might appropriately know as much and might, upon appropriately intimidating queries, say as much. False accusations of methamphetamine production. Oh, this really gets good. Here continues the theme of warrantless entry to a domicile and an anomalously aggressive police conduct. Remember that the police have already made on forced warrantless entry under the instruction and with the natural assistance of Jacques Cousin, as such, fully aware that it is a residence. On or about August 1st, 2017, Lisa Tucker, while visiting the commercial properties, noticed a noxious odor and then called she noticed a noxious odor and then called the police, just as all sensible people do after suffering olfactory insult. Of course, she probably did smell something distinct, given that, as she knew, she was standing adjacent to an auto body shop. One of the bays, all right? Automotive paint is not known for her resemblance to potpourri. Despite the obvious origin of the smell, an entire team of officers, or perhaps a hazardous materials team, arrived shortly thereafter and spent hours inspecting the contents of the shop, with particular emphasis on a child-sized inflatable pool. The contents of this pool were as follows: A. Water. B. Soap. As far as is known, no warrant for entry was obtained for this instance either. Mr. McGahee later requested any available documentation on this incident, but was told none was where am I at? None was generated. Clearly, this is a lie. I have it on good authority, which nevertheless wishes to remain anonymous, that such documentation does exist and does identify the initiating event as a phone call by Lisa Tucker reporting a methamphetamine production laboratory. I have it on the previously mentioned authority that it is case number H-31085-17. In summation, the least that can be said in this incident clearly establishes Kent's innocence, as entire evidence team spent hours inside of his residence found nothing. Again, the speed and scope of police response, especially when viewed in the light of the nominality of the evidence, indicates a strong and pre-existing prejudice against Mr. McGahee. In conclusion, the kindest interpretation of these events that reason and sincerity allow me to state that many of the police officers, attorneys, and even judges, not all of which named herein, have blatantly failed in their obligation to maintain the appearance of propriety. Indeed, these events lead me to suspect much worse. Not that my opinion is dispositive, but I do expect the evidence here presented amounts to anything like a solid case for the criminal prosecution of anyone. However, this certainly provides reasonable suspicion warranting further investigation and perhaps even probable cause with which to gain access to clearly incriminating evidence. To this end, I have attempted to indicate where I believe such evidence may lie. However, these suggestions are hardly exhaustive. Powerful evidence may lurk in quarters unanticipated by me. As a Mandarin proverb states, trouble never travels alone. I fully expect that the persons named herein have used similarly manipulative tactics in other matters, and a search for evidence in this matter may well reveal clear evidence of collusive or otherwise criminal activities in entirely different matters. Kind regards, Matthew Lella. Thank you, Matthew. It took balls to write that. You know, him and I have lost contact, but thank you, Matthew. It did come to good use. It was totally ignored in 2017. Totally, completely. Nobody fucking bothered. I still haven't got a call back from the FBI. As a matter of fact, one phone call, I told him, you know, what is your public duty? To investigate corruption, right? Yeah. They still wouldn't help me. Okay? There you go. Bunch of fucking criminals. That's what we got in Iberia. Fucking criminals. Organized crime. And they're going to be eradicated and removed. Fuck that. We don't need criminals in our society. We have a hard enough time getting by without fucking leeches and criminals and fucking murderers calling the shots. It's just gonna get fixed. I didn't want to do this. I warned everybody not to do this. Well, the days come. Now they can understand why I warned them.